Mr. Willis is one of the first cases I had when I came to Warren County, and now he's finally back again.
And I've argued that with my attorney, and it's just like this, saying that I was going to take these charges, and I told him I could even beat one of the charges, even though I'm guilty of it, but I could have beat one of them. And he told me, what's one more felony? It's a probationable offense.
Judge, I most certainly did not say that.
Absolutely, you did.
This is State of Ohio versus James Willis, case 25CR42365. Mr. Willis is present with his attorney James Bogan. The state is represented by Brian Goodyear. We're here for sentencing. I have reviewed the pre-sentence investigation. I've reviewed the victim statement. I've reviewed the letter from Mr. Willis's paramour. Is there a statement from the victim?
Judge, the victim is not present, but she did ask Ms. Kennard to read a statement. Ms. Kennard is stuck into the courtroom, so I'm going to read a statement that the victim asked us to read on the record.
Is it the same one that's in the PSI?
I didn't have time to see the PSI, Judge, so
Okay.
I'm not sure.
Do you know, Melissa?
I'm not sure.
Okay.
Oh.
Go ahead.
I'm not sure. I believe it might be. She submitted a couple different ones.
She indicated what was stolen from her, what a hardship it was on her,
Yes.
how she actually gave him a ride, and
Yes,
when he got out of the vehicle and to get his bag, he stole her purse
that's correct.
to thank her for that.
So you got a chance to read
Yes,
that?
I did read
Okay,
that.
perfect.
Okay. Is there a statement from the state?
Yes, Your Honor. Obviously, Judge, you're aware that we're speaking about a sentencing for an F4 and F5 and misdemeanor of the second degree. So these are not high-level offenses. However, there are two things that I want to highlight for the court. Number one, obviously, Mr. Willis has a substantial prior criminal history dating back a number of years in other states and in Ohio. He was convicted of theft in 2025 in Franklin. He was convicted, he had a pending case. It looks like maybe, I don't know, wherever Grand Superior Court is.
That sounds like Indiana.
Yeah, I wasn't sure, but it just says, it doesn't say the state as far as I can tell. He had a number of open cases, but he's been previously convicted of burglary in Florida on, it looks like, more than one occasion, forgery, theft, attempted robbery. He has a number of prior criminal offenses that, from the state's perspective, indicate that he's a longtime criminal who has shown an inability to be law-abiding. He just continues to commit criminal offenses, including the offense in this case. Your Honor, I would point out that, I want to make sure I remember this, to mention this, there is a request for restitution in this matter, Judge.
There is?
There is.
I thought there was none on the PSI.
There is,
I
Judge.
saw some specifics in the letter, though.
Yeah, the total is, it's not substantial, it's $193.68 to the victim. That's the restitution amount for the items that were taken from her.
Okay.
But in addition to that, Judge, I want to point out that not only is he a career criminal, he also is someone who showed this court specifically he's not willing to follow any rules or listen to the court's orders because, as you're well aware, he cut off his ankle monitor and he's been gone now for quite some time. As a matter of fact, Mr. Willis is one of the first cases I had when I came to Warren County, and now he's finally back again. So from the state's perspective, Judge, I think when you have someone who has that criminal history, who has proven to you that he is not going to follow your rules, the only choice is to incarcerate him. So it's the state's request that he be sent to prison for 18 months, and then that the court also make the restitution order that I mentioned.
Okay, thank you. Mr. Bogan, anything on behalf of Mr. Willis?
Judge, on behalf of Mr. Willis, he has 99 days jail credit, and as you can see from PSI, he's been in for about a month and a half since he's been picked up. He does have drug issues, as you've seen from PSI, and given that there's also a recommendation from Talbot House for a psychiatric evaluation, looks like we're dealing with dual diagnosis here, which they're recommending a psychiatric evaluation to see if he needs medication for that, because if he does indeed have a psychiatric condition, then he's going to need to treat that and his drug issues side by side. And I would ask that he have an opportunity to have this looked at. So let's see if we can try to nip this kind of conduct in the bud.
I think it's too late for that, isn't it? With the record you just heard?
Well, Judge, I always have to advocate for my client.
I know, it's just not a very, well, maybe it may be good, but it just doesn't seem like it applies in this case. Nipping it in the bud generally means as it's beginning. This is one that began a long time ago. Go ahead, though, Mr. Bogan.
Well, Judge, if this is, I don't know if I've ever seen anything in his history before where there's been any kind of psychiatric or dual diagnosis, evaluation, or treatment. That's why I'm wording it the way I am.
Okay, fair enough.
And if he's had a psychiatric condition that's been overlooked all these years whenever he's come in contact with courts, as you know, Judge, if somebody's just getting drug treatment, they're dual diagnosis. Treating one, if you're only treating one, you might as well not be treating either of them because it's going to be very incomplete treatment. This is an opportunity here for him to get both treated.
Are you finished?
Yes.
Okay, thank you. Mr. Willis, is there anything you'd like to say, sir?
Yeah, he was stating, for one, he was stating a criminal record. I haven't been in trouble with any thefts or anything since 2014. Yeah, I've got a criminal record, and the reason I did this was not for drugs. Me and my fiance, we moved up here, and the landlord that she had kicked us out because I moved up here with her, and our car blew up in the same week, and it was snowing and it was cold out, and I did do what I'm guilty of, but it wasn't for drugs or alcohol. And secondary is, upon even agreeing to this, because I didn't really know this open plea ordeal, I was told, take an open plea, what's one more felony, that I would get probation. That's a probational offense, and that's when I agreed on this. And I did that. I told them the same thing. I messed up, and I did do what I did. It wasn't for drugs, and it wasn't for alcohol. It was to get out of the cold. We weren't from here, and when I left, I got a call saying, well, my fiance got a call saying that I missed a drug test, and that's why I cut the ankle monitor off, because I didn't know that I missed it. And when I called probation, they said, you missed it, you got to report by 9. I asked them if they would come to me and give me a drug test at the hotel. At that point, we were staying in a hotel. They told me no, and I cut it off and we left. But I wasn't dirty on drugs. I've never failed a drug test. But we don't live. The difference now compared to then is we live in a house. We have a vehicle. I live right around. I'm on 3 years probation for my driving offenses and everything that my recent crimes, which is driving without a license. I had a possession of marijuana because there was marijuana in the car, and it's illegal in Indiana. But I haven't had no burglaries, and I've never been convicted of a robbery or attempted robbery. I've been convicted of burglary, thefts, and grand thefts. And my last time being convicted of any of those was in 2014, and I got sentenced to prison for it. I just don't. There's not a pattern. I messed up this time, and I'm not saying the reason I did mess up is good or justifiable. I can complete your probation. I'm not going to fail for drugs. I passed every drug test. I've never failed one, and I didn't push for this case to be pushed on the drugs because it's not. You're going to use the system for what you're going to use it for, at least make it accurate. And I've argued that with my attorney. And it's just like this, saying that I was going to take these charges. And I told him I could even beat one of the charges, even though I'm guilty of it, but I could have beat one of them. And he told me, what's one more felony? It's a probationable offense.
Judge, I most certainly did not say that.
Absolutely you did. You
Okay.
argued with my fiance about it.
Just
But-
go ahead.
And just like calling his off, I mean, I've never got a motion to discovery, I've never got anything. And you coached me into taking this plea and saying I was getting probation, because it's a probational offense. 4s and 5s are minor in this court, that's your exact words, and I stand on that.
Okay,
But I did break the law. I am guilty of it, but it's not, I can complete your probation. And I just wish for a chance because I do got a family and I don't need to fall further behind in child support. And I'm sorry for coming to this state and breaking the law. And I haven't broke the law here before. I was trespassing one time, that was it. But my record's bad, but the conviction rate of it wasn't bad. So some of the charges he was saying, I wasn't even guilty of it. They actually got dismissed.
well, they did dismiss some in exchange for a plea agreement.
No, they dropped, in some cases, they dropped all the charges.
I thought you were talking about this case. You're charged with 2 counts of receiving stolen property.
That's correct.
You stole a car.
Right,
You stole a purse.
right.
You stole a credit card. You stole a cell phone. All of this affected a woman's life
That's correct.
in an impactful way. And this is a person who actually tried to help you. How likely do you think she is to help anybody else because of what you did? Then you ran, then you hid under a truck. So that's what's your sentence is based on.
All right.
Okay. On count 1, the sentence is 12 months. On count 2, the sentence is 12 months. On count 3, did he plead to count 3?
The obstructing, yes, sir.
Okay. The sentence is 60 days. Those 3 are to run concurrent for a total prison sentence of 12 months, less credit of 99 days?
Yes, sir.
Okay. You have a right. First of all, this carries post-release control, which is supervision by the adult parole authority, meaning when you're released, they can supervise you. It's discretionary, but they can supervise you for a period of up to 2 years. If you violate post-release control, they can send you back to prison for 6 additional months. If you are convicted of a new felony during that period of supervision, the court that has the new felony case can revoke post-release control, impose whatever time remains on supervision. If you have less than a year remaining on supervision, they can add a year to the sentence in the new felony. There's $193.68 restitution ordered. You have a right to appeal this sentence. You have 30 days from today to file a notice of appeal. If you cannot afford an attorney will be appointed to represent you. Is there anything I've not covered, Mr. Goodyear?
I don't believe so, Judge.
Mr. Bogan,
Nothing I can think of, Judge.
do you have any questions, sir?
So I don't go to no programs or nothing?
I'm sorry?
I'm not going to any.
Well, actually, the prison is the largest mental health provider in the state.
No, I'm asking.
That's it. I mean, they whatever programs are available, you should be eligible for them. Okay, that's all.